Okay, so as a lawyer, should you be doing favors for your opposing attorney? And the answer to that is sometimes, sure. It depends on where you practice, but I think in most jurisdictions the answer would be a qualified yes. One of the things I think you need to learn is there's a mentality that might come from law school or maybe the perception of what lawyers do, that you always oppose your adversary. You never give up, you always fight, you never concede. In actual practice, that doesn't work so well. And we'll talk about the kind of things that you might be doing as a favor to your adversary. In my experience, a lawyer that I find to be exceptional has this ability to be a zealous advocate for his client or her client, and at the same time, cordial with his or her opposing counsel. And there is a way to do that, and the good lawyers know how to do that. Before you walk into the courtroom, very, very professional, very personable, very nice. In the courtroom, we're doing our job. And my job is to attack your case. Not you, but attack your case. Those are the good lawyers. So you have to get away from the mentality that absolutely not, this is my adversary. I would never do my adversary any kind of favor. There's a difference between accommodation and advocacy in the actual practice of law. Now, one caveat here. Kind of depends where you practice. My practice is in upstate New York. And in upstate New York, that is definitely the rule. If you can do a favor for your adversary without affecting your client, you do it. Everybody does it. Down in the southern part of the state, in New York City, I'm not sure it's quite like that. So you have to get a feel about how that question is being answered in the geographic area that you practice. Now, the key to whether you give any kind of accommodation to your adversary is obviously, can I make this accommodation? Can I help this lawyer without affecting the rights of my client? And many times the answer to this, sure. Let me give you an example. Could be, let's say, an extension to answer some documents, maybe an answer to a complaint, maybe it's a response to a motion of some kind, and you get a phone call from the lawyer who says, man, I am just, deluged here with work. I am not going to be able to get this to you by a certain date. Can I get an extension? Now, it's always up to the client, but you kind of, advise your client that this is how it works here. The answer isn't normally or automatically, no, you can't. The question is, what are you asking me? If I can provide this attorney with an extension to accommodate his practice, and we all need extensions, trust me, you're going to need one, and your adversary is going to need one. That's just the nature of the practice. We're very busy people. And when your adversary is simply saying, I need some time, almost always, depending on where you practice, the answer to that is yes. Now, there may be circumstances in the particulars of your case where you can't do that, and there may be an abuse of that. Sometimes it's the first time, then the second time, then the third time, then the fourth time, and at some point you have to say, look, I've been reasonable here with you, but this is the last time you're getting an extension. And if he or she asks again, you have to say no. So it depends on what they're asking, but if it's something that can be done without prejudicing the client, and the client agrees to it. And a lot of times, you'll ask the client, this lawyer is really busy, wants an extension. The decision is yours. Almost always, the client says, well, what do you think? And you say, well, around here, we kind of do that for our colleagues, and it's not going to hurt your case at all. Whether this paper's in my office by Friday or a week from Friday, it's not going to make any difference to the case. The client usually says, well, okay, then we'll do that. But it depends on the area of practice, but those are kind of the rules about whether you should do a favor for your adversary.